Pardoning is a practice common to all cultures throughout all periods of history. In this presentation, we will briefly discuss its ancient forms and the experience of England and the colonies. We will then explore the constitutional foundations of the pardon power as interpreted by the United States Supreme Court. After a dabble in some of the more interesting legal questions surrounding pardons, we will then review empirical data so as to understand broad trends and current practices, and to clear up a variety of misperceptions. Finally, we will explain why this important feature of our system of checks and balances and separation of powers is needed now, perhaps more than ever. Although there was no formal equivalent for the word pardon in ancient Greece, the power of amnesty rested with the people. So mercy would be extended to individuals whose pleas were supported by a petition signed by 6,000 citizens. Of course, very few succeeded at this, but for obvious reasons, popular entertainers, athletes, politicians, and the wealthy were at a distinct advantage. The Romans were prolific for political use of pardons, granting them to please segments of Roman society, to encourage patriotism, to celebrate holidays, to moderate discipline in the army, and to moderate punishment of opponents. In a decimation process, Roman soldiers lined up the conquered enemy and executed every 10th person. The Germanic tribes featured an astounding variety of pardons. An individual might be pardoned if an execution attempt failed, if a prisoner would agree to execute everyone else in a group of condemned prisoners, or if an onlooking virgin were to pick him out for marriage. In an apparent attempt at parody, the Germans would line up captured Roman soldiers and pardon every 10th person. In the British Isles, the pardon power was claimed and exercised by feudal lords, the clergy, and Parliament, but by the time of Henry VIII, it was the unrestricted power of the King of England. There followed a very sorry history of controversy and abuse. Pardons were granted to celebrate the birth of children or birthdays. Criminals were spared on the condition that they join the army or relocate to the colonies. Pardons were also used as tools of extortion to replenish the treasury. One king divided pardon profits between the two women then most in his favor. Colonial history featured a steady displeasure with and eventual restriction of executive power, including the power of pardon. This displeasure was manifest in the Articles of Confederation, which gave largely symbolic power to the executive and no pardon power whatsoever. States took the pardon power away from governors altogether, or required that pardons be approved by a board or legislative body. Some offenses were exempted from pardon. Rules of procedure were also developed, and some states required public notice of pardons. Ambivalence toward the power was also evident at the Constitutional Convention. Neither of the major plans, the Virginia Plan or the New Jersey Plan, contained a pardon power for the executive. Nor did the power appear in the first draft of the Constitution. A single member of a committee, John Rutledge, however, scribbled the power into the margin of a draft. As a result, convention delegates did not discuss the power until the end of the day, just before the convention was about to adjourn. What little discussion there was focused almost entirely on concerns over potential abuse and the need to further limit the power. This is certainly not to suggest that the pardon power is the most important issue at the convention, or even that it deserved a great deal of attention relative to the other issues of the day. But it is to say that any suggestion that the power was carefully considered and/or debated at length by the founders of the Constitution is false, or misleading at best. Article 2, Section 2 of the Constitution reads, "The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment." The Supreme Court has interpreted the aforementioned language to create a broad clemency power for the President, to forgive federal offenses and offenses committed in the District of Columbia. The Supreme Court has also interpreted the power to include the ability of the President to grant pardons, which relieve the recipient of all punishment, conditional pardons, commutations of sentence, which reduce the severity of a sentence, conditional commutations of sentence, respites or reprieves, which merely delay the execution of a sentence, remissions of fines and forfeitures, and amnesties or group pardons. These delineations and the broad nature of the text of the Constitution have, of course, given rise to numerous points of debate and further elaborations on the scope of the power by the federal courts. For example, can the president pardon someone before they've even been charged with a crime? Does the president have to give a reason for a pardon? Can the president pardon someone for any reason at all? Can a president cancel a pardon granted by a previous president? Can the president place any condition that he wants to on a pardon? Can a pardon be granted to someone even if they didn't ask for it? Can a person refuse a pardon? Can the president pardon himself? Can the president pardon someone who is dead? Today, there is an Office of the Pardon Attorney in the U.S. Department of Justice, which processes clemency applications and makes recommendations to the Deputy Attorney General. On average, presidents have granted almost 100 acts of clemency per year for the last 90 years. So these actions occur with much greater frequency than the average person might think or guess. In recent decades, however, the number of applications for clemency has increased. To some degree, this would be expected, given growth in the general population, the number of convictions, and the prison population. But as you can see from this chart, the growth in applications has not necessarily been incremental or intuitive. Commentators have attributed much of the elevation on the right side of this chart to the abolition of parole in the federal system, the over-criminalization of the law, the advent of mandatory minimum sentencing statutes, and the so-called war on drugs. Whatever the cause, the increase in clemency applications has created a pattern of backlog in the Department of Justice, so that in a typical year, many applications are simply left pending. While there has been a dramatic increase in clemency applications, there has been an accompanying decrease in the use of the pardon power by presidents. While there is some debate as to where exactly that decrease began, this chart makes it plain that the trend did not begin yesterday. Commentators explain the decreasing use of clemency as a result of the creation of alternative release mechanisms in the early 1900s, such as probation and parole, the advent of national news media, the law and order campaigns of Richard Nixon, and of course the controversial pardon of Richard Nixon. Of course, the consequence of skyrocketing applications and infrequent use of clemency is very long odds against receiving executive clemency. Here's what the number of positive grants looks like when charted against the number of denials in recent decades. Here's what the number of positive grants looks like when charted against the total workload of the Office of the Pardon Attorney. Today, if someone beats the very long odds and receives executive clemency, they will most likely receive a pardon. That is to say, commutations of sentence and the other forms of clemency we have discussed are freakishly rare. This is important to know because the popular perception of pardons, springing criminals from jail and tossing them into the streets, could not be more false. The typical, as in 95+% pardon, recipient has served his or her time, has integrated back into society as a law-abiding productive member. The offense they have committed is usually minor. It was usually committed decades ago. And the effect of the presidential pardon is simply to restore their rights. The right to vote, the right to serve on a jury, the right to hold public office, or own a hunting rifle. Put another way, the typical presidential pardon is given to someone who has established a record of rehabilitation, which has withstood the investigatory powers of the FBI. There is no controversy involved whatsoever. The president pays no political price. No political capital is spent. The media hardly even notice. To date, President Obama has pardoned 17 people. Can you name any of them? The hesitancy of recent presidents to use the pardon power may be seen in other trends. They've waited longer and longer before even granting the first pardons of their administration. They typically grant the largest number of pardons in the fourth and last year of the term. And 1 out of every 2 pardons granted over the last 39 years has been granted in a single month alone, the month of December. The pardon power has been universally recognized as a necessary component of legal systems, and it remains an important part of our own system of checks and balances and separation of powers. The inflexibility of common law in England and in the colonies invited mercy and discretion. Literally hundreds of offenses were punishable by death, and the law made no distinctions, for example, between first-degree murder and manslaughter, or juvenile and adult offenses, or even consideration for the mentally ill. The pardon power, however, allowed the executive branch to address these considerations. Likewise, when laws were overly broad, had unintended consequences, or were enforced in an overly zealous manner, or perhaps even in error, a pardoning executive could correct the legislature and the judiciary. In the Federalist Papers, Alexander Hamilton noted clemency powers could be useful in times of insurrection as a bargaining tool and an inducement to resolution and peace. He also argued that easy access to mercy was necessary to counterbalance the tendency of the legal environments to become overly rigid and cruel. In addition to all of these concerns, there has long been recognition that in some instances, mercy is warranted. Justice can be served. Offenders can pay the price, rehabilitate, and render themselves worthy of forgiveness. Today, our nation's booming prison population has prompted fiscal conservatives to consider alternatives to incarceration, especially for first-time nonviolent offenders with excellent records of conduct. Libertarians believe far too many behaviors are regulated, subject to criminal sanction, and that clemency powers should be used to make a statement about over-criminalization of the law and the so-called nanny state. And on the liberal end of the spectrum, many have long lamented the heavy-handed emphasis on retributive justice in our system and the inflexible nature of mandatory minimum and three-strike statutes. In sum, many believe the pardon power is needed as much as it ever has been, if not more than ever.